class number 10. Today we'll be analyzing American labor law. Again, just broad strokes, just going over the basics that you can use to help you with your legal practice and maybe with your research into American labor law. So we're going to be focusing on vocabulary mostly. To start off, the Fair Labor Standards Act is a bill from the 1930s, part of the New Deal with President Roosevelt and after the Great Depression. And basically what that did was that it created minimum standards for worker safety and worker well-being, right? So things, like the 40-hour work week, the minimum wage, those were things that didn't exist before and which were introduced by the Fair Labor Standards Act. What's interesting is that similar to our own labor regulations, they initially did not apply to agricultural workers. And in fact, to this day in America, agricultural workers still have a different treatment, usually a worse treatment than urban workers, which is also the case here. Also, the National Labor Relations Act. This is important because a lot of labor relations in America are governed by labor boards, are governed by unions, and not really by the government. So a lot of these labor disputes are solved in these sort of private courts, with they're mediated, so there's a lot of mediation that happens when a labor dispute happens. So the cases don't necessarily always go to court like here. This is a different system. There isn't a specialized court for labor disputes like the one we have in Brazil, or even the one they have in Germany. It's dealt with more through things, like labor boards and labor unions. In fact, you have the Occupational Safety and Health Act, which is usually just shortened to OSHA. So when someone says it's an OSHA violation, they're saying that those working conditions are not safe. It leads to some sort of accident. So that's a violation of an OSHA violation, which applies to all states. So they have to be observed. So the Family and Medical Leave Act, this is interesting because in America today, there's no maternity leave. So this is sort of a middle ground for that, but there's no really maternity leave. It's a lesser regulation than what exists in other countries. And then you also have the Civil Rights Act. This is part of it was to prohibit discrimination on the basis of race. It comes to the workplace. So those kind of cases, if they're litigated, they usually are litigated successfully because of the Civil Rights Act and also because of the Supreme Court's interpretation of the 14th Amendment, which is what we reviewed in the previous class. Then you have the Americans with Disabilities Act, also to prevent discrimination on the basis of disabilities, to prevent employers from snooping into medical records, so you have the right to not reveal your disability. And age discrimination. Also, there's a lot of discrimination especially against female workers when it comes to age. So basically, if you're still older and you still want to be in the workforce, this act protects against discrimination based on the basis of age. Then, in addition to that, obviously there's state laws. There's too many state laws to go over. There's 50 jurisdictions and also the territories. If you're working with a certain individual from a certain state in the United States, you can look into their own state laws. Yeah, so basically what I just explained, the Fair Labor Standards Act and the National Labor Relations Act, which are the most important pieces of legislation concerning labor relations in the United States, but also everything else. This is just a summary of what we just went over. Collective bargaining in unions. These are things, that we are familiar with here. Unions, they have, there's a bit of movement, an anti-union movement, and at the same time, a pro-union movement in the United States recently. You have these large corporations. So yeah, basically just a summary here of the things we just went over. Here we have the key terms, basically what we did, and collective bargaining in unions. Well, like I said, a lot of disputes in the United States when it comes to labor law are mediated by these labor boards. So it's very important to have union representation. And a recent problem that has happened is that you have these very large corporations without union representation. Two examples which are being very heavily discussed right now are Starbucks and Amazon. There's an attempt by a lot of Amazon and Starbucks workers to become unionized. And in many states, that's been hampered by right-to-work laws. Basically, that means that you cannot be forced to pay contributions to labor unions. Your employer cannot sign a contract saying that you have to pay contributions to a labor union, and that's basically taken away a lot of funding from labor unions. So much so that with the recent attention being given to labor law after the pandemic, there's been an effort in some states to repeal the so-called right-to-work laws, whereas other states have been basically making it harder to form a union. So really, it's a time of political turmoil on a lot of matters in the United States right now. So at-will employment, Basically, you can terminate the contract at any time you see fit. Then you have exempted and exempt employees. Like I said, the labor regulations, they have a lot of exceptions. Initially, they didn't really apply to agricultural workers. Now they're supposed to, but in a different way. And a lot of times you have undocumented immigrants working in these in agriculture, so they end up not getting paid nearly as much as they're supposed to be paid. Wage and hour laws. Basically, in the United States, you get paid by the hour. That's usually how the wage is perceived. And minimum wage laws regulate wage by the hour. There's a federal minimum wage, which really has not been changed in several decades, so it's really become outdated. It stands at, I think, about $7.50 an hour. And obviously there's local ordinances regulating the minimum wage. So, even municipalities can have their own minimum wage because that's something that really impacts the local life, right? So cities with a much higher cost of living will usually tend to have a higher minimum wage. So you think of something like Los Angeles or New York, whereas rural areas with a lower cost of living might have a lower minimum wage, but it cannot go under the federal minimum wage, which is, like I said, right now, $7.50. But obviously there's an effort. A lot of people say that it should be at least $15 or $20 an hour because of inflation in the past 4 decades. So it's been a really long time since the minimum wage has been adjusted. Basically, the only way to really get paid to really alter these minimum wage laws is that if you're working with tips, usually there's exceptions that allow you to factor in the tips that you're supposed to receive. There's a big culture of giving tips in the United States. So whenever you use a service, especially in the restaurant industry, you're expected to give a tip. And it has to be a sizable tip. Here, it's always included. We have the 10%. It's mandatory. But in the United States, it's up to the customer, and it's really considered extremely rude not to tip because that directly affects the employee's bottom line because the tips go to them, basically, and actually they receive a decreased salary as a result of the tips that they're expected to receive. So yeah, basically you tip as much as you see fit, but it's socially not very acceptable to not give anything or to give a very small tip. Yes, so basically minimum wage and overtime pay being the extra pay you receive if you go over the amount of hours you're supposed to work, or if you go over the 40-hour work week, you get overtime pay. It's additional pay. It's especially, there's no specific regulation for night work, but you can have a contract, you can have some sort of a labor agreement or some sort of contract that gives you extra pay depending on what time of day you work. Also, this is from the Labor Board versus Jones and Laughlin. Basically, when we were studying constitutional law, I said the Constitution doesn't regulate a lot of things, and it doesn't give Congress expressly the power to regulate labor relations. So the Supreme Court in the 1930s, in order to uphold the validity of these new bills that were being introduced to regulate labor, they basically decided that, well, since Congress does have the ability to regulate interstate commerce, according to the Constitution, then this really is a way to regulate interstate commerce because it creates just minimum standards that all states have to obey and prevents them from sort of having a race to the bottom to see who can have the loosest labor laws. Yeah, today different states have different minimum wages and different labor regulations, but they really the Fair Labor Standards Act would be the minimum at a federal level. Yeah, so basically you have here's some things. This is from the U.S. Department of Labor, which is responsible for a lot of these regulations. Fair Labor Standards Act regulates established minimum wage, overtime pay, record keeping, youth unemployment, and status affecting employees. Youth employment is a big issue in the United States right now. There's a lot of states rolling back protections against, basically child labor, but you work by minors, so 14, 15. There being the possibilities for work to be performed by minors is being expanded in a lot of states. So this is something that's generating a lot of controversy at the moment. Basically, collective bargaining and representation advocacy. Like I said, usually the way contract disputes are resolved involves labor boards and council meetings. It doesn't necessarily involve, going to the courts, especially because, I talked about this in a previous class, but going to court in the United States is extremely expensive. No matter who you are, you're expected to pay for the fees and your attorney yourself. So there's no possibility of having, a free legal representation in a civil matter provided by the state. Obviously, that's the case in criminal law, and we study that in criminal procedure. That's mandatory according to the Gideon versus Wainwright case. But when it comes to civil matters in a civil court, you're expected to pay for your own expenses, and that is a huge problem for people with low income. And obviously, if you're receiving a minimum wage, you're not going to be able to afford a lawyer, especially because the legal profession is harder to access in the United States, so there's a much greater shortage of lawyers there. Attorney fees tend to be much higher there than they are here, proportionally speaking. Yeah, so basically training, companies provide training. This isn't obviously very surprising. Obviously, that worker safety and health, so they also train you on how to comply with OSHA regulations, because you have to comply. It's not just the company that has to comply. Basically, hazardous and nighttime work. So hazard pay, it encompasses both insalubridade and periculosidade here, what we have in this country. So if you're doing anything that can be considered hazardous, you're usually entitled to additional pay as a result of that. Nighttime work, like I said, is not something that is directly regulated by Congress, but obviously, because working at night is more uncomfortable and harder, there is usually, in order to entice employees, there is usually some sort of additional pay being offered. That's going to depend on, the local regulations. So yeah, collective bargaining agreements. So like I said, labor unions play a huge role in this, and they used to be much more powerful. Really, movement to decrease their powers in the 1980s and the 1990s. In the 70s and 60s, they used to be much more powerful, which is why a lot of, if you watch old movies, there's a lot of talk about, the labor unions, and they did have a much greater control back then than they do today. That's been part of a movement to really deregulate, the labor sector and reduce protections, and we see that here as well. So minimum wage. It's $7.25, but it doesn't matter too much because this minimum wage at the federal level here is so low that it can't really be practiced anywhere, because with this minimum wage, it's simply not worth it to work. So you're going to be hard pressed to find any business using this minimum wage, even though it would be legal to do so. Usually you're going to see at least $8 or $10, because below that it's just not viable for the employee, to go to work and to sort of work 8 hours a day. But yeah, this is what the minimum wage is in America, according to federal law. State law and local ordinances could be different. Managerial employees are basically people who are tasked with managing, so it's a trust role. It has many similarities to what we think as a cargo de confiança. So they have lesser work protections because they are sort of halfway between boss and employee. So it's not the same protections that apply to regular workers when you're a managerial employee. And freelancers versus employees, this is probably the biggest discussion happening in labor law today. Like here, in the United States, you're not supposed to skirt labor laws by having people hired as freelancers, which is why the California Supreme Court, they came up with something called the ABC test. Basically, 3 criteria to determine whether or not someone is actually an employee, even though they're being described as a freelancer. Well, let's skip ahead to that. The worker is free from control and direction of the hiring entity. That's one part of it. The worker perform work that is outside the usual course of the hiring entity's business. So, someone who's basically, going to go and clean the school. The school's business is, teaching, if you're a private school. So if you go there and clean, maybe you could be considered a freelancer. Obviously, you're going to have to fulfill the other 2 criteria as well. But like I said, this is from California, so it's not going to be, you could use this as precedent to argue in your favor, but it wouldn't really be binding necessarily in other states, because it does come from the Supreme Court of California. Yes, and the worker is customarily engaged in independently established trade, occupation, or business. So basically, if the employee only works for you, even if they fulfill the other 2 criteria, it's still probably going to be considered an actual employee and not a freelancer. So this is actually a little bit stricter than what we have here. We really loosened these rules regarding freelance work in Brazil recently. And going back here, you see other things such as exclusivity. Does the work only work for you? Is he only allowed to work for you? Because that's usually something that really separates an employee from a freelancer. A freelancer cannot have exclusivity, because if they did, they wouldn't be a freelancer. And the duration and continuity, if someone's working under you for several years, it's going to get harder to argue that they are really a freelancer. So usually freelance work is supposed to be temporary. Right, so here's some case law. Basically, this is a more constitutional law. The other stuff here is going to be dealing with labor law more specifically. But like I said, you're going to have to read a lot more case law than this if you're really planning to work with labor law in the United States. especially if your clients are Brazilian. You're gonna have to look into immigration law, because there are a lot of there's a lot of law regulating how labor is supposed to be performed by immigrants. You're supposed to have a work visa. You cannot do it on a travel visa. So a lot of these laws here don't really touch on the issue of a lot of this case law here doesn't touch on the issue of immigration, which is probably what might interest you more. So I would certainly recommend that in addition to studying labor law in America, if you're going to work with that, you should also study immigration law. So yeah, basically, I hope you could learn some basic vocabulary here regarding labor law. Like I said, you still would have to study a lot more in order to be able to practice labor law effectively. That's it. I guess I'll see you on our next lesson. Okay. All right. So in addition to the laws and acts that we've discussed, there's also the Family and Medical Leave Act, and this is problematic because you can see here it's unpaid leave. So it's up to 12 weeks of unpaid leave for newborns or other family reasons. But because it's not paid, most people don't take the 12 weeks. Most people, just take a few days, because if you go 12 weeks without being paid, basically that's 3 months without a salary. And because, a lot of people work, the minimum wage is very low, most people cannot afford to take the 12 weeks of unpaid leave. And even these 12 weeks, which is the legal limit of what companies are required to provide, is still below what the international standards. I think the international recommendations would be around 16 weeks of paid leave. So it's 12 weeks unpaid leave, even for new mothers. So also, the Civil Rights Act, very important, preventing discrimination on the basis of race. And the American with Disabilities Act, which are also preventing discrimination with the basis of disability, also protecting the medical privacy, so you don't have to disclose a lot of information regarding your disability or your medical records to your employer if you don't want to. So these are just some bills that are important for labor regulations in general. In the United States, obviously you should go more into depth because they're big bills, they have a lot of provisions. And also you have to study the case law regarding these different bills.